we heard one too many horror stories of a client that didn't know how big of a deal this was. And then they got hit with a cease and desist letter and were forced to rebrand.
Welcome back to the Pitch to Product podcast. I'm Jack Dalton, Business Development Manager at 52 Launch, and I'll be your host today. I'm joined by
Joey Vitale, trademark attorney.
Yes, founder of Indie Law. They have filed over 2,000 trademarks, so they know what they're doing over there. Somebody that 52 Launch has worked with for a little while now, and experience has been excellent so far. So, Joey, happy to have you here. Thank you for the time.
It's a blast and an honor to be here, Jack. Thanks for having me. And I know we both know how important it is for your audience to understand the importance of this stuff and the consequences if they don't think about this ahead of time.
Oh, yeah. Oh, we're going to get into that. And on that note, today we're going to be doing a deeper dive on trademarks. So we're going to be covering how they fit into your business plan, when it makes sense to get one, how you actually use a trademark. And then, of course, we'll cover the common, how much they cost, how long does it take to get one, all that good stuff and more. So stay tuned for that. Awesome. So kick it right off here. I have heard trademarks defined as a source identifier for a particular good or service. That's not the most accessible definition. So I'm wondering, before we get into the weeds, if you could kind of define what a trademark is for us.
Yeah, Jack, I love that we're starting here because I've given so many presentations on webinars and in front of people all around trademarks. And the first few years that I was doing these talks, I was really struggling. I would get to the slide of here's what a trademark is. And I could see people falling asleep in the back of the room. I found that just giving the definition, which was accurate, Jack, isn't very helpful for people. So instead, what I like to do is this, and you guys just know that I am not putting Jack on the spot here. We didn't talk about this ahead of time, but Jack, I believe that this is a softball question for you. If you had to guess, what company do you think owns the phrase Hakuna Matata as a trademark?
Would that be Disney or DreamWorks?
Disney is correct. Yes. So what made you guess Disney?
That's where it came from.
Yeah. So when you hear Hakuna Matata, you think of Lion King and you know that Lion King is owned by Disney.
Right.
That thought process is what makes a trademark a trademark.
I like that.
So anytime that we as consumers see or hear a phrase or a logo or something, and it makes us think that there's a particular brand behind it, that thought process it's called source identification, and it's a sign of a trademark being a trademark. So it's not, people talk about getting your brand name trademarked and kind of filing for this process. And that's kind of true, but a trademark isn't something that you like file for and get really. What you're really doing procedurally when you're acquiring trademark rights is you're saying, look, Nike has already done the work for branding so that when you hear just do it, you think of Nike.
Right.
So when Nike files for trademark protection for just do it, they're not saying like a domain name, we want to buy the rights to just do it. They're saying we now have built a track record or are building a track record of this thought process that's happening with customers. And we're protecting that thought process.
Right. Yeah, that's a great example. It makes a lot of sense. Yeah, absolutely. So on that note, and those were some interesting examples. When do you think it makes sense for people to start thinking about a trademark? And I'll kind of start with how we usually think about it from the, our sort of limited perspective, where we're mostly bringing consumer products to market under very small new brands. And generally what we advise our clients to do is, if they haven't, to go create a business entity, either an LLC, S Corp, C Corp, something that is separate from their personal identity. And then as soon as they've decided on a name that they really like, they should go find out whether it's trademarkable. And then from there, if it is, they should trademark it pretty much right away.
Yeah. So I'm going to flip the script on this question a bit, because a lot of people, they think of, when should I trademark, from a place of like, hey, I've got a name, or I'm thinking about a name. I kind of want to vet and validate first that it's going to be strong, that the product's going to be successful, before I go through the process of claiming it through trademarks. I want to encourage all of you to think about this from a completely different place, because trademarks are not about claiming what you want to use like a domain name. You really need to be thinking in the first place about not accidentally infringing on the rights of others.
Right.
Most trademark applications actually get denied. Over 500,000 applications get filed every single year.
Well,
and the biggest reason for a refusal is that it's too similar to another trademark. That's why the most valuable thing that we do is a really comprehensive search to make sure that you are having a successful path to getting registered. I say that because naming and trademarking, there's a lot of it depends to a strategy, but I will say that the best businesses that we work with that have, the background of having established business owners doing this stuff, larger businesses with larger budgets, the best practice here is to come to a trademark attorney or a trademark law firm with the list of potential names, so that before you find that one name that you love, that you start getting emotionally married to, we can help you whittle that list down to what's most likely to call dibs on as a trademark.
Yeah, that makes perfect sense. I think that's what we try to do. We always come up with a list of names and encourage people to whittle it down to a few, because there is that phenomenon where people get really attached to a certain name, and it's almost like, oh, well, I can't trademark it. I don't care. I'm using it anyway. It resonates with me. It resonates with my brand. It resonates with who I think is going to purchase this product. But absolutely. And that's a great segue into one of my next questions, which is, I think there's a common, I don't know if I'd call it a misconception, but there's a belief that you go out and you file for a trademark, and then your brand is protected. Nobody else can use your name for similar goods and services. You're all set. But just the existence of a trademark doesn't really stop other people from using your name, right? You have to actually do something about it and somehow become aware of them using your name. Obviously, if you've got, maybe you could cover this in this answer as well, if you've got that R in a circle next to your brand name on Amazon, certainly that's dissuading anyone else from using a similar name.
Yeah.
But
Jack, there's a lot of stuff that we can get into. I want to start here first. I want to give you all some context for why I even do what I do. Because before I was a trademark lawyer specifically, I was just a business lawyer. And if you looked at our website at the time, it kind of looked like a Starbucks menu. There were a bunch of different offerings on our site. Eventually, we took everything off the menu except for trademarks. And it's because we heard one too many horror stories of a client that didn't know how big of a deal this was. And then they got hit with a cease and desist letter and were forced to rebrand.
Yeah.
I say that to start this, what might be paragraphs long response, Jack, because I like thinking about trademark protection as playing defense and offense.
Yep.
The first thing we have to do is play a strong defense so that you never get blindsided with the cease and desist letter yourself.
Absolutely.
Once that's in place, then you can optionally play offense as much as you want to. But you're right, Jack, when it comes to playing offense and enforcing your rights against others, trademarks don't enforce themselves. So just because your trademark is registered, that does a lot in helping you play defense and avoiding a cease and desist letter, being forced to rebrand, which could cost $200,000. but there's that offensive strategy that will take extra time and effort and budget on your end if you really want to be protecting your brand well.
Right. Yeah, that was a great reframing of the question, which was maybe a bit too broad, but
Oh, it
um
was a great question. And you also brought up the circle R. So real quick on that,
right.
there's really two different layers of trademark rights in the US, two main layers. One is called common law trademark rights, and the other one is registered trademarks. I've got pretty young nieces and nephews, and so sometimes I try and test my marketing with them to see if they understand it. And so I like to use this metaphor with them of a house versus a fence. And just by building your house, just by technically using your brand name, you do get automatic trademark rights. They're called common law trademark rights. And they give you exclusive rights regionally to your business. So back in the day when you just wanted to protect your brick and mortar pizza shop from having a copycat across the
Right.
block, common law trademarks were sufficient. But you don't really have a strong fence around the house until you register your trademarks. That beefs up your exclusive rights to uh, federally, it's like an electric fence saying anything that's too close to this is going to infringe it. And the cool thing about common law rights is they're free to claim, and that's what that TM symbol is short for. So the good news for all of you and the quick tip is you can slap that TM symbol no matter where you'd like to put it, you can put it for free. And most business owners don't know the difference. So it
Right.
can be a strong deterrent, but you do not want to rest too easy until you get that circle R secured.
Yeah, I think a lot of people don't know that you can just start using the TM logo as soon as you're doing business under the name of your business,
Yep,
which is I've had a lot of clients be pretty surprised to find that out.
totally.
Because it's, yeah, I think people think it means a little bit more than it does. But then there's the circled R. So yeah, I'll let you explain.
No, well, the only thing that I want to just add to that to help clarify things for your audience, Jack, is that um, many businesses, many business owners, just because of the way that we see things in the public, and especially I think your audience, Jack, there's a lot of talk that we hear just as consumers about patents and patent pending.
Yep.
Patent pending means something in the legal world. There's really no such thing as trademark pending. And we sometimes hear people say that because it just sounds like it should be right. But while you can and should be applying for a trademark registration, having that application be pending like doesn't really give you any rights. There's no special symbol for that. So I just wanted to clarify that distinction in case that trips anybody up.
Yeah, absolutely. So the TM you can use, you know, from whenever you start getting into business. And then the R, you have to actually have a registered mark, correct?
Correct.
On the brand name. So there's a couple different types of trademarks. Now might be a good time to kind of cover maybe types of trademarks might be the wrong word. All right, I'll let you explain. But there are multiple different things that you can trademark.
Yes. So and feel free to add to this list with what you're thinking, Jack. Um,
Mm-hmm.
the common types of trademarks, and you can really trademark anything if you get creative, but usually we're talking business names, logos, slogans. Again, it's anything that has that Akuna Matata effect. When I
Yeah.
see that thing, I think of this brand. So some brands are big and creative enough to trademark even a color. So Tiffany blue, that shade of blue is trademarked for Tiffany. And
Yeah.
what like Reese's orange
Right. That's the
is
one I know.
trademarked that orange color. You can even, if you really want to be creative, trademark a smell. And I love this example. So Verizon, they ended up not doing it, but they were testing a certain scent that they were going to put into all of their stores. So it
Huh.
smelled like a Verizon store. And they actually
So
trademarked that smell.
I like that. That's uh that's that's good. I think I saw a news headline recently that Taylor Swift was trademarking her voice.
So that is a really great thing to bring up. What I will say is, if one of the coolest and most helpful things that you can do to be protected is just to do what Taylor Swift does legally. Like if you go on the trademark office and you see the types of things that she's applying for,
Yep.
it's a really strong example of just a best practice. In terms of her trademarking her voice, this is something that a lot of celebrities are doing right now to try and combat AI.
Yeah.
And what's really interesting is, um, it's so new that none of these, to my knowledge, have been accepted yet. They haven't been denied. They're just so new
Okay.
that they're still pending. And
Right.
even if and when they get registered, I think it's going to take a couple of court cases to figure out, okay, does that actually limit what a Claude or a Chat GPT can do?
Yeah. Yeah, that is certainly interesting. Um, I'm not going to claim to know what a trademark application on a voice would look like, but
Very interesting. It's hard to know what you're looking at when you're just reviewing the PDF version of that application.
yeah. To get into what trademark applications look like, I think another question that I get relatively frequently is, you're telling me I should go speak to a trademark attorney. What do I need to have for that conversation in order for it to be productive?
Mm,
So, what are the questions that you need a client to be able to answer about their brand when you're preparing to file an application?
really good questions. And I want to be clear of the way that I answer this. It's really important for us to understand what your business does,
Right.
because there are 45 different classes or categories that exist with the trademark office. And I actually think that this is really genius. The trademark office has accomplished something like beautiful here, where they've taken anything that you can imagine selling and it can fit under one of these 45 different classes.
That's pretty cool.
And so we have to be clear on what it is that you sell so that we know what class and what description to use so that your trademark application doesn't get denied. The asterisk that I want to add here, and this throws a lot of clients off because they tell us what we do or what they do, and then when we show them the application, they're like, "Were you not listening? This is not at all what I told you that I did." Just be prepared here because, again, most trademark applications get denied. The trademark office is looking for any reason to deny your application. So, one thing that a strong trademark law firm will do is, we won't just take your definition of what you do at face value. We look to already approved descriptions,
Okay.
and we
Yeah, that makes
use
sense.
pre-approved descriptions as much as possible so that the trademark office is likely to accept it. We
Yeah.
want to avoid any scratching of the head that they're doing, because at the end of the day, whether or not they accept your application might come down to like whether they ate a donut in the morning that made them sick. So we
Yeah.
really want to make sure that we're minimizing anything that is going to make them slow down on your application.
Yeah.
And so don't be too off guard if the description that a trademark attorney comes up with for what you do sounds a little bit like legalese and is pretty far away from like how you would describe what you do on your website.
Yeah. Yeah, absolutely. And I'm glad you touched on the classes because we've had clients who have chosen a name and they're really attached to the name, but they do a quick Google search and, maybe they want to be selling something that would go under like a clothing class and they search the name and maybe they've chosen an odd name and up in the search bar pops a new AI agent that's using the same name. And they think somebody already got it. I can't trademark it. It's gone. It's being used. So
No,
would they still
I'm
be
glad
able
you
to
bring
use
that
it?
up, Jack, because this is a huge problem that we see people that try and do their own trademarks
Yes.
experiences.
Yes. And
The,
more and more
the
people are trying
trademark
to do
search
their own.
database, it's really cool that it's free. It's this government website you can use to look up trademarks. But a lot of people make the mistake of they run a search, they see that someone else has their trademark or something like it, but they don't think about the fact that what they've applied for is in a different class or it's completely different. And just to clarify how nuanced this can even be is it's not the math and the analysis here is not as simple as like if it's in the same class we're going to deny it, or if it's in a different class we're going to allow it.
Right.
There are interrelated classes where those types of classes tend to be, you know, sold in similar places. We this was a while ago, but I love this example. We filed for a gym's trademark, and we were pretty confident that it was going to go through. But the the examining attorney, in my opinion, was wrong, and they flagged it because they thought that the name of the gym was too similar to an apparel company, and their argument was gyms can sell clothing, and so they're in the same channel of commerce. We wrote back and we're like, look, this other apparel company, like they're not in like the athleisure wear. That's not the type of brand that would be at a gym. And so we were
Right.
able to overcome it.
Oh,
Using a
that's cool.
completely different example, we applied for a trademark for a podcast brand. And they were initially worried because someone else that was also in the same podcast class had a very similar trademark. We took a closer look at it, and yes, they were both podcasts, but one was about marketing for business owners.
Yep.
The other one was helping people walk their dogs better. So,
Yeah,
because
those are
they
pretty
were
different.
reaching a completely different audience, we could make the argument that they were different enough to coexist under the same class.
Yeah. Yeah, absolutely. That's cool. It's two good successes.
Yeah.
Perfect. So, as somebody who's looked at the USPTO trademark registration, that website, which is actually quite user friendly and
Yes.
clearly has been updated semi recently because it's much better than most government websites.
Yes.
There's kind of a lot going on. It's, if you're using normal words, you're almost always going to get some hits on whatever you look up in that database. I'm still pretty unclear on what some of the tags mean. So you'll see a lot of trademarks in there that are, forget exactly what the words they use are, maybe dead or abandoned.
Yep.
So it's not like patents, right? Where any prior art, if somebody's used the name in the past, you can't use it now. If something is abandoned, can you then take that name, even if it's in the same class that one was? Or does it maybe depend if the company is still in
Yeah.
business, but let the
Okay.
trademark lapse?
Jack, I'm loving this. So, apologies. I'm going to step back again and just try and provide
Yeah,
context.
good.
I can answer this as well as I can.
Perfect.
One thing that is really important for smart business owners to wrap their minds around is that when you are claiming that you have rights to a trademark, those rights actually start based on who was the first to use, not who was the first to register or even who was the first to file. So it is possible, even if you do your research and you see that someone owns a trademark registration, if you have strong evidence that you were using it before they were in a similar
Yeah.
class, in a similar channel of industry, you could petition to cancel their registration based on prior use.
Hmm.
Now, you
I
have
didn't
to
know that.
spend money to make that effort. But I want to be clear here because a lot of people get confused on, oh, if something is already registered as a trademark, even if I've been in business for 20 years and didn't know it, I have to that's not how this works.
Okay.
That being said, this live versus dead or abandoned stuff, you're right to call that out because that is important and confusing. So when a trademark application is applied for, it is marked as live if it's either pending or it's registered.
Okay. Yeah,
It's
that makes
marked
sense.
as dead if it either was refused and never registered, or if at one point it was registered, but that registration has lapsed.
Yes.
And either way, when a trademark has been marked as dead, that is no longer a red flag that we consider. So, um, and this is actually, it gets to a really important point. People might not have the foresight to think about the fact that even once you get your trademark registered, there is ongoing maintenance and renewal filings that you have to stay on top of to keep your
Hmm.
registration alive. And the timing of that is a little weird. So it's 5 years after your registration and then 10 years after that, every 10 years. So it's
Easy
long
enough.
enough that a lot of people just forget to file the renewal
Right.
paperwork and then it
Right.
accidentally goes abandoned.
Mhm. And you can keep doing that forever, right? There's no
Yes.
cool. So
As long
unlocking
as
that.
you're continuing to use the trademark as a trademark.
And so one quick kind of clarifying question back to classes and kind of in the context of us working with people who are just starting a business, who are launching one product. If you wanted to amend a trademark down the line to include a new class of goods or services, can you do that or do you have to file a new one or
You would have to file a new one. And this is a
okay.
really important thing to know for businesses that are thinking about expansion or filing for new trademarks and stuff in the future. Um, it is possible to amend an application, and you can amend a trademark application to like change ownership, or
Yep.
you can amend it to constrict. What we'll sometimes do is we'll file a trademark application and it'll get initially like refused, and then we'll amend the application to basically delete that language that was the problem. So you can amend by removing, but you can't amend by expanding what's in the
Okay.
application.
Gotcha. Yeah, that's perfect. Um, great. Yeah, so kind of jumping over to a new topic here for a sec. Let's talk a little bit about what goes into enforcing a trademark, and I'll kind of give you a specific context for this.
Great.
Um, let's say you're a solo inventor, an entrepreneur that has launched a product that's been out on the market for 6 months. You've got a trademark, you're selling 1,500 units a month on Amazon, and somebody else noticed that and said, nope, I bet I can list this a little bit cheaper and take all their sales. What would you do as the entrepreneur to use your trademark to protect your brand and your market position?
Yeah. Well, there was one really important phrase that you added, Jack, that I really want to underline and highlight like three times, which is they were taking all your sales. To me, that's the crux of this. And I hear all the time from business owners who see a copycat, and immediately there's just this sense of like that isn't right, that isn't
Yeah.
ethical. There's this sense of like ego and pride, which I totally get because I've been on this side of things as well, where it's like that shouldn't happen. This isn't right. We have to go after them. I get all of that, and we have to be thinking of objectively as business owners. Is the juice worth the squeeze there? Is it worth it to spend time, money, and mental effort to enforce your rights against them? So 100%, if you are measurably seeing a huge consequence to your business, then it's financially better for your business to get them to stop versus letting it continue.
Yeah, absolutely.
So I would take next steps there. You can always start with what I call a good cop letter first. You don't need an attorney to do this. And we've had a lot of clients that have reported success here where it's just like hey, I wanted to just reach out personally. You might not know this, but I own this trademark. Please take XYZ steps. You can do that. Um, Depending on the situation, and I think this makes sense in the situation that you brought up as an example, Jack. If the trademark infringement is happening on a platform like an Etsy or an Amazon, usually those platforms make it really easy to report the trademark infringement. And
Yeah.
if your trademark is registered, then that platform tends to be really helpful in just doing the work for you of removing those product listings, whatever. If that's not the case, then you can send cease and desist letters. Usually it's helpful to get an attorney involved at that point. Even a strongly worded cease and desist letter, um, the other party doesn't have to respond or reach out to, although it's not a good look. So ultimately, if it's a bad actor that is ignoring you, it might take starting and winning a lawsuit to get them to stop.
Right. But you said something that's pretty key to our audience, which are, generally our clients are not at a point where they would be excited to engage in a multi tens or hundreds of $1,000s lawsuit. Oftentimes, let's use Amazon as the example. Amazon will just delist the other product for you if you have a registered trademark and you're in their brand registry. That is huge. I mean, that's just that makes it worth getting a trademark in pretty much 100% of cases for the clients that we work with, because
Agreed.
obviously Amazon is the biggest marketplace in the world. And so if you want your product to be as relevant as possible, you're probably selling there.
Yes.
And you don't need to actually go to the legal system to solve the problem if you've trademarked your brand. And if you haven't, then you can't do anything.
I love this point so much. And I think it's worth stepping back as a business owner and thinking about how it's pretty cool that Amazon was smart enough to think about how, okay, if you as a business owner can show us that your trademark is registered, that's almost like the equivalent of people showing their driver's license or birth certificate or passport of like, this is proof of you being who you say you are, owning what you say you own. And so it I think is really smart of them to say, okay, that is the evidence that we're going to want that is going to unlock various benefits for you. On a related point, and Jack, this is a newer development, so you and your team might not even realize this. I only caught on to it earlier this year. Um, it's not just Amazon that is paying attention and having this idea of using trademarks as a cool, like, piece of evidence to use that unlocks benefits. Google recently came out with this new wrinkle to what they do, where if you can show Google that you own your logo as a trademark, you can file paperwork so that your email gets a special Google verification badge, so that when you send your company emails, and you'll notice this if you look up like
Yeah.
Gusto, for example, they have a little blue check in Google, the same way that you might see a blue check on Facebook or Instagram or wherever.
Yeah.
Only way to get the blue check with Google is through a logo trademark. But when you get it, it's number one, a cool just sign of like loyalty and legitimacy, but it also improves your email open rates. And emails that get sent with the blue check can bypass the spam and promotion folders.
I did not know that. I'm actually surprised I didn't know that, because
Isn't that crazy?
that's big. I mean, email marketing is absolutely huge, and if you can take your open rate from 5 to 15%, that is
Massive.
massive for your business.
Yes.
So, wow, that's one of the most compelling reasons I've heard to kind of immediately get a trademark on your logo, because most of our clients trademark their logo, but all of them get a word mark on the name. I don't know if that's the correct word there, but
Yes. Yeah.
Trademark the plain text version of their name, which is what you would use for the Amazon brand registry. That is very interesting, though, and something that we should probably pursue as a business if we don't have already.
Yeah, well,
Yeah.
you and I and our teams can talk more about this.
Yeah.
It's a very, uh, I think it's just a really interesting example of what's to come, and I think in the future, with AI and market saturation, it's it's going to be more and more important to have these signals of trust.
Yeah.
And it
Oh, I
seems
couldn't
like
agree more.
trademarks are becoming like a global entry equivalent of, if you do the extra work and can show us this, then it can just unlock certain shortcuts and doors for you.
Yeah. And so I don't know anything about this, so I won't have quite as good a question for you. But how, I assume if you, how do international trademarks work? Do you have to file in every jurisdiction that you want to own your brand name in?
Yeah, so it's interesting. So there's really no such thing as an international trademark. And we often hear from companies that are outside the US. And they're like, hey, should I get a US trademark? And we're like, it's not about where your business is based, it's about where your audience is. And so a lot of companies outside the US, they prioritize a US trademark first for two reasons. One, because they have a strong audience still in the US, even if it's not their main market. But number two, the US is just more litigious than the other countries that they're doing business in. So it usually makes sense to start in the US. But most countries have signed on to an international treaty that basically allows shortcuts on the back end, so that once your trademark is registered in one country, you can file through this special way to get your trademark that is registered in one country like reciprocated quickly and registered in another country.
Yeah. Okay. That makes sense. That,
But you will have to file filing fees for every country that you add to this, and
mhm.
those can add up very quickly if you want like all of the countries to be
Right.
registered.
Right. Yeah. I can see that getting quite expensive. Um, yeah, that's good to know. On the topic of price, because this is always one of the big questions, how much do trademarks usually cost? Is there generally a difference in price between trademarking your brand name versus a logo versus one of those other wacky categories that we were talking about?
Yeah, so whenever it comes to cost, there's really two different buckets to consider. One is the trademark filing fees themselves. So even if you try and do this on your own, you're going to be paying about $350 per class that you file in. If you want an attorney's help, um, you're probably going to want to spend a couple $1,000s minimum to work with like a quality law firm that you can trust. What's interesting here, and we're seeing this more and more, is most of the applications that get filed in a DIY way get rejected because people just don't know the difference. And Jack, I'm sure you've seen some on the marketing side that like AI is great, but it's only as good as you prompt it. And if you don't know how to prompt it around this certain stuff, then your application is doomed for failure.
Yes, if that isn't the truth, yeah, it's all in the prompt, and we've had a lot more clients in the last couple of months than ever before when the topic of trademarks comes up say, well, why shouldn't I just do this on my own? And my first thought is always that, okay, they saw some AI tool or they just think that they can do this via ChatGPT. And I'm sure ChatGPT or Claude or whatever can write an extremely compelling trademark that sounds like it was written by an attorney. But as you said, the chance of getting your trademark approved if you do it on your own is significantly lower. And this might be a good time to touch on how long it takes for a trademark to actually be approved, because I've heard something like 7 to 9 months. You can correct me on that.
It takes
But
on average 18 to 24 months.
even better, this will prove my okay.
Yeah.
That yeah. I mean, that's a significant amount of time. And if you wait that whole time, and as our clients would be, you're building your brand in that whole window, you're going
Exactly.
to market in that time, you're actually building a business, and then to 2 years later get a notice that nope, your brand name, you can't use this brand name. There's a too high likelihood of confusion with somebody else's brand. You got to change your name. That's a big setback.
Yeah,
That
it really is. We I was recently told by a client that we were reassuringly expensive. And I was like, oh, I really like that
that's
phrase
good to hear.
because I want to point out just the risks of going the DIY or cheap route. So, like you said, Jack, there's just so much room for error if you try and do this yourself, and the timing is so long that there's that real cost of like you don't want to have to go through this process more than once. Especially, I mean, you don't get your money back if at the end of the 18 months
Yeah.
it's it's not available anymore or it's denied. The other thing that is really important to keep in mind is that when you file your trademark application, every single application that's filed is a matter of public record, which means, unfortunately, that there are a bunch of scam artists out there and they target a lot of DIY filers and
Mm.
write letters, send emails, send voicemails, sounding like they're the trademark office, saying that you have to pay extra money to get it through. And I can't tell you how many times our clients. So I will say that when you work with an attorney, a lot of spam artists are smart enough to know not to touch those applications
Yeah.
because they see that they're being helped. But we still receive a lot of clients sending us text message images, email photos of, we just got this scary letter in the mail. Do we actually have to respond to it? And we can just say,
Wow.
sorry you received it. It's totally spam. Feel free to shred it. Um, the other thing that I want to be mindful of here is, and I want to be careful in how I say this because there are a lot of great trademark attorneys out there, and it's not really in my nature to go after like my competitors. But what you will sometimes see if you search for a trademark attorney and you see some that are way cheaper than maybe others that you're looking at, some lawyers, just like business owners, will try and make it a benefit to working with them that it's like a one person shop. It's like, hey, if you work with me, you'll know that I will be on top of your file. You can reach out to me at any time. As a business owner myself, that raises red flags because what happens if that lawyer gets hit by a bus or even goes on vacation? Does that just mean that the office closes down? And to that, I'm really proud of the team that Indie Law has built and our processes. We've have over the years designed a machine that takes care of our clients, so that whether it's me or anyone else that goes out of office or something happens, because I've been a one man shop before, I know what I've grown away from, and I think that there's a lot of just peace of mind that we can give our clients, knowing that we have several just worst case scenario plannings in place so that our clients are always taken care of.
Yeah. Yeah, absolutely. A good team and good systems. You're speaking 52 launches language
There
here.
we go.
Yeah. Um, absolutely. So I think we've covered most of what I wanted to touch on. Certainly, I always think that stories that you can share about either successful exits of brands that you've trademarked or the horror stories are often even more compelling about cease and desist letters 5 years into a business that's
Yeah, well,
had some
I do
serious
need
growth.
to respect confidentialities, but I will say that
Right.
one trend that I see that is just really tragic, but I could see this happening with a lot of your clients and your audience is, if you think about it, a lot of copycats come out when you're visible.
Mhm.
And we have talked to so many clients who they thought that they were smart by waiting to get trademarked. And then it's because their business goes viral online or something happens and a celebrity buys their stuff or whatever, and they get super excited. But that huge spike in visibility is when the copycat creeps up, or when
Yep.
someone else sees what you've done. They see that you haven't filed your trademark, so they file a trademark before you get around to it. Those are really the tragic things that we see, where people,
Yeah.
they knew all of this stuff. They thought they were being intentional about waiting, and then they get blindsided by this. Another thing, this is a common theme of a, not a mistake, but just a really best practice. We talk to a lot of clients that um, are in a like pre-production stage in their business. They've gone to someone like you guys, and they're packaging everything. They haven't gone to market yet, but they've spent the tens of thousands of dollars or whatever to get ready. When you file for an application normally, you have to show evidence of use in commerce. A
That's
lot
a
of
great
business
thing to
owners,
touch
they
on.
see that and they think, okay, wait, that means I have to launch first and then trademark. There is a second way of doing this called an intent to use trademark basis.
Yes.
And we work with a lot of product based companies in applying for intent to use trademarks for this reason. Again, we want to follow Taylor Swift as a best practice. She always does this. She filed for the name of her latest album after she released the name but didn't release the album yet. Her team was very quick to file an intent to use trademark application for Life of a Showgirl.
Yeah. Yeah, that makes sense.
So don't think that you have to wait until you launch to the public to get the paperwork started.
Yeah. I mean, pretty much all 52 launch clients file ITU or intent to
Yeah.
use trademarks. So it's perfectly viable and makes a lot of sense, especially if you're not just thinking about going to market, you're actually on your way to being in the market. You know,
Yes.
it's you have intent to use it.
Exactly.
So yeah, that makes a lot of sense. Um, obviously trademarks are part of a larger business strategy, a go-to-market strategy. Where, if there's anything that we haven't touched on where trademarks add significant value to a brand, you know, anyone going into business, anyone starting a company should, in the back of their mind, probably have this thought of, if someone ever wants to buy this thing, I should probably be willing to sell it. Exits are a success in business most of the time.
Yes.
So, I guess we could touch on, how do trademarks make that easier, or how does it make it really difficult to achieve a successful
Yeah.
exit
Well,
if
and
you're
I'll be
going
quick
on
here because I know we
naming a
don't have a
brand?
lot of time, Jack,
Right.
but a couple of things to really keep in mind. One is that I love that 52 Launch is encouraging all of its clients to shift away from personal brands to uh, business names, logos, slogans that aren't just personally tied to the owner. Um, Mostly for these exit strategy reasons. It's really hard to leave a company, and we're seeing a lot of lawyers do this because it's so common to name your law firm after your own
Yeah.
name. When they eventually want to shift away and sell the law firm, it can be really hard and difficult with an audience to explain what that means. Um, but more directly to your question, Jack, is trademarks are one of the very few examples of assets that can be a specific line item when it comes to a sale.
Cool.
And
I didn't know
so
that
when
either.
you're thinking about actually putting out a job offer or explaining, okay, what's our worth for the company, um, trademarks are a very rare asset that you own that can be listed as a line item. We do not do trademark valuations. That's a really kind of different breed of stuff. But as you plan for an expert, you do want to make sure that you have a trademark valuation expert on that like board of advisors to maximize the valuation.
Yeah, that makes sense. Perfect. I think we covered just about all of it. Certainly at 52 launch, we feel like trademarks are just always make sense. With a constrained budget, trying to get to profitability as quickly as possible. Patents may or may not make sense. It can be a much more significant investment, even longer timelines. And sometimes they're actually a little bit harder to enforce, or a lot harder to enforce.
Yeah.
Trademarks always make sense. It's like it's
They
part of
always
a
make sense, and I really, as much as it is a best practice if you can to work with an attorney, I'm also very committed to doing everything I can to make price not a barrier. So I can send this to 52 launch later, but like I've got a book
we
legally
can put it
legit.
in the video description.
Yeah, I've got a book legally legit that walks you through the steps that I would take if I was sitting next to you working on your trademark application. We've also got
Nice.
a DIY course as well that is like working with a law firm. And so you can use that course to complete a search and get your application filed in about 3 hours if you have that time and you
Wow.
want to do it your own.
Yeah, that will certainly be of interest to this audience, I'm sure. So we'll link all of that in the description below. People can find you at indielaw.com.
Absolutely. Thank you so much for to Jack and to all of 52 Launch for having me.
Oh, thank you for being here. Your expertise is much appreciated. And if anyone listening has a product idea that they're thinking about getting serious about, book a call with Joey, book a call with me. We both offer some free consultation time. And even if you don't end up working with us, you'll certainly learn something and you'll have made another step in the process of getting to market. So thank you for listening to this episode of the Pitch to Product podcast, and we'll hope to see you next time.